This video is intended to give you an overview of some of the key aspects of estate planning before you meet with an attorney so you can make the best use out of your time with that attorney. This video is intended for informational purposes only. This video is not legal advice, and this video does not form an attorney-client relationship. When lawyers use the term estate planning, they're usually talking about 4 different things. First, disposition planning. This determines what happens to your assets when you die. Second, disability planning. This designates who makes medical and financial decisions for you in the event you're unable to do so. Third, wealth transfer planning. This is how wealthy people attempt to minimize taxes and retain family wealth. And fourth, special asset planning. This is used for people who own certain assets that need careful consideration for management after death, like family vacation property or closely held businesses. Nearly every adult can benefit from a disposition or disability plan. This is because these things happen to us all, regardless of our wealth or the nature of our assets. So the rest of this video will focus on those 2 things, and when I say the term estate planning, I mean disposition and disability planning. So exactly what is estate planning? Well, let me ask you a few questions. Do you know what happens to all of your assets when you die? When you're alive, what happens if you can't make decisions for yourself? Who makes those decisions? And how do they get the authority to do so? And if you're unable to care for children, who takes care of your children? And who picks who takes care of your children? In the simplest terms, without an estate plan, the government answers these questions for you. An estate plan opts out of these government defaults and allows you to make the choices. Let's get more specific. When you die, the government default is that all of your assets will be given to your heirs in a specified line of succession. In most places, all of your assets would first pass to your spouse if you have one and they're living. If not, your assets will go to your children, and then your grandchildren, and then your great-grandchildren. And if there are none of these, then the line starts over again, starting with your parents. So first your parents, then your siblings, then nieces and nephews. Now things can get complicated if you have children from a different relationship, but you get the general idea here. With an estate plan, you can opt out of these defaults and choose where your assets go. Maybe you want everything to go to your surviving spouse, except your grandfather's journal from World War II, which should stay in your family and you want it given to your brother. Or maybe you want something a bit more complicated. The point is that you get to choose. So that's where the assets go when you die. There's also a default for how the assets get there. If you don't have an estate plan, in most cases, a court will oversee the asset transfer to your heirs through a process called probate. You can limit or even avoid probate entirely with certain types of estate planning. So if you want your heirs and beneficiaries to be able to avoid the probate court proceeding, you probably need an estate plan. In summary, the disposition part of an estate plan lets you pick where your assets go on your death and how they get there. In the disability planning context, if you are incapacitated, meaning that you can't make decisions for yourself for whatever reason, the government default is that a court needs to appoint someone called a guardian to make decisions for you. You can opt out of the need for this court process by creating documents called powers of attorney, which proactively designate people to act if you're incapacitated. I know this is vague and we'll get to more detail later in the video. For now, let's talk about what many people consider the most important part of an estate plan. If you're no longer able to care for a dependent, like a minor child, usually a guardian needs to be appointed through a court proceeding. Without an estate plan, the court will try to appoint the most appropriate person as the guardian, based on a lot of factors and input from your friends and family. If you want to have a say in this process, you can nominate these guardians in your estate plan, and maybe that makes everyone's life a little bit easier because they don't have to guess or squabble about what you wanted for your children. Let's talk in more detail about disposition and disability planning aspects of your estate plan. To understand what an estate plan does, you first should understand what happens if you don't have one. If you become incapacitated while you're living, someone will need to be able to make medical and financial decisions for you. Third parties, like doctors and financial institutions, will often require legal documentation that the person claiming to act for you has the actual legal authority to do so. Without an estate plan, the way someone gets this legal authority is by being appointed guardian by a court. This is a whole structured process that takes some time and effort. It can last days or months, probably will incur court costs and attorney fees, and typically involves at least one semi-public court hearing. I say probably and typically because each state has different laws, so this is just to give you a general idea. Here's an example of a typical guardianship proceeding. You become incapacitated. Now someone needs to be able to make financial decisions for you. First, someone needs to file a petition for guardianship with the court. Within 90 days of this filing, the court holds a guardianship hearing. And before the hearing, all of the following things need to happen. The court appoints someone called a guardian ad litem to represent you, and that person will need to meet with you or at least review your file to determine what's in your best interest. At the same time, anyone who's nominated to be your guardian needs to file disclosures with the court, giving the court information about their criminal history, bankruptcy records, or anything else relevant to being your guardian. A medical professional provides a written report to the court about your condition, and notice of the hearing is sent to interested parties at least 10 days before the hearing. At the hearing, the court considers all of the information and determines whether a guardian is necessary, who that guardian should be, and what powers that guardian should have. If a financial guardian is appointed, that guardian will need to file an inventory of your assets within 60 days, and then will need to provide verified reports of your income and expenses to the court every year until you no longer need a guardian. The benefit to this process is that it's slow, deliberate, and supervised by a court with ample opportunity for the court to hear and consider the opinions of all the interested parties. The downside is that this is a significant amount of work, and as you can imagine, can cause delays and incur expenses. The disability planning part of an estate plan is intended to eliminate the need for these guardianship proceedings. Essentially, you opt out of this default. The way it works is that you, when you're well and competent, sign documents giving these powers to people you specify. The documents are typically called powers of attorney. There are usually two types, financial and healthcare. To complicate matters a little bit, you can make specific choices about your healthcare in something called an advanced medical directive, living will, or declaration regarding medical care. This document goes by a lot of different names, but often attorneys refer to this as a living will. Sometimes the healthcare power of attorney is combined with the living will in one single document. The thing to know here is, while you're healthy, you can choose people to make financial decisions for you and have those same people or other people make medical decisions for you. If you signed these documents before becoming incapacitated, your family could avoid the cost and delay of guardianship proceedings. A financial power of attorney allows you the ability to grant another individual, called your financial agent, legal authority to act on your behalf regarding your finances. That means your agent will have the ability to do things like access your bank accounts, pay your bills, file lawsuits, and make other financial decisions for you. A financial power of attorney can become effective either immediately upon signing or only in the event you become incapacitated. When deciding whom to appoint as your financial agent, consider that this person should have the following qualities. They should be trustworthy, organized, responsible, reliable, and able to interact with financial institutions. A healthcare power of attorney allows you the ability to grant another individual, called your healthcare agent, legal authority to make healthcare decisions for you. Your healthcare agent will be able to access your medical records, talk to your doctors, direct your healthcare providers. You can grant or limit authority for your healthcare agent to make certain decisions. A healthcare power of attorney is effective only in the event you become incapacitated. These agents should have the following qualities. They should be trustworthy, knowledgeable about your healthcare preferences, able to respond to healthcare providers on short notice, and comfortable interacting with medical professionals. For both financial and healthcare powers of attorney, you can name as many agents and successor agents as you like. Most people name one primary and one successor of each type of agent. You can also name two or more agents to act together as co-agents, but be aware that naming an even number of co-agents presents the possibility of a deadlock when these co-agents are making decisions. Before you meet with an attorney, it would be helpful to write down the full legal name, phone number, and address of any individuals you're considering appointing as your agents. You can discuss these topics in more detail with your attorney. You should also consider what medical decisions you want your healthcare agents to be able to make. Consider the following. Would you want feeding tubes or life-sustaining procedures used if you were in what's called a persistent vegetative state? Generally, the term persistent vegetative state means the following. A condition that reasonable medical judgment finds constitutes a complete and irreversible loss of all of the functions of the cerebral cortex and results in a complete, chronic, and irreversible cessation of all the cognitive functioning and consciousness, and a complete lack of behavioral responses that indicate cognitive functioning, although autonomic functions continue. Second, would you want feeding tubes if you had a terminal condition? And generally, a terminal condition means the following. An incurable condition that reasonable medical judgment finds would cause death imminently, so that the application of life-sustaining procedures serves only to postpone the moment of death. You can discuss these topics in more depth with your attorney. I pose these questions to you now because I found that clients prefer to be prepared to answer these questions before meeting with an estate planning attorney, rather than be blindsided by such difficult questions. Now let's discuss guardians for minor children or other dependents. If you have children or are the acting guardian for anyone else, your estate plan can nominate guardians for such individuals in the event that you're no longer able to care for them. This is a very important part of estate plans for parents, so please discuss this topic in detail with each other, or if you have children from a prior relationship, you should discuss this topic with your children's other parent if they have any custody or visitation rights. Ultimately, the court is what will decide who will take care of your children, but the court will give significant weight to the guardians you nominate in your estate plan. The guardianship process for your children will be much easier for everyone involved if both parents nominate the same guardians in each of their estate plans. Now let's talk about disposition planning. If you die without an estate plan, the court will oversee the transfer of your assets to your heirs through this process called probate. Some websites estimate that the probate process costs between 2 to 8% of the estate's assets for things like accounting fees, attorney fees, and court costs. And the probate process typically lasts 6 to 18 months. That means for an average estate of $250,000 of assets, probate could take about a year and cost about $8,000. These are general estimates, and I don't know if there's any actual reliable data on this, but this gives you a general idea. If you have an estate plan, probate can be limited to certain assets or even eliminated completely. First, let's get some perspective on how assets are transferred at death. Disposition can be made by any of the following methods, depending on the nature of ownership attributes of each asset. A last will and testament, beneficiary designations, the ownership type of an asset, or revocable trust. The last will and testament is the most well-known estate planning document. The will disposes of all property held in what's called your probate estate. Your probate estate is essentially anything you own in your individual name when you die. Certain assets will never make it into your probate estate, and thus will pass without regard to the provisions set forth in your will. Assets with beneficiary designations and ownership types of some assets can cause them to pass outside of probate. Life insurance is the most well-known type of asset that commonly has a beneficiary designation. When you die, the life insurance policy proceeds will be paid directly to whomever you named as a beneficiary on the policy account paperwork. For example, if the life insurance policy paperwork names your spouse as a beneficiary of your policy, and your spouse is living when you die, the insurance company will pay the policy proceeds directly to your spouse as soon as it's notified of your death. It won't wait for the probate process, and it won't need to see what's in your will. Retirement accounts also typically require that you name a beneficiary when you open the account. However, this does not mean that life insurance and retirement accounts will never pass through probate. These assets can be subject to probate for a few different reasons. If you fail to name a beneficiary, or if the beneficiary you named is not alive and you didn't name a contingent beneficiary. If this occurs, the asset will be paid to your estate, which means it'll be governed by the terms of your will and it'll pass through probate. The ownership type of assets also may cause them to pass outside of probate. Property titled with phrases like husband and wife as survivorship marital property, or husband and wife as joint tenants with rights of survivorship, will pass outside of probate if the other owner is living at the time of your death. Typically, you'll see these phrases on things like the deed to your house. This is not an exhaustive list of ownership types. In different states, you'll see them called different things, and also people write a lot of funny things on paperwork. If you see something funny, Google it or talk to your lawyer. Also, joint accounts will pass outside of the probate process if the other owner is living at the time of your death. For example, if you have a bank account that's titled husband and wife checking account, ownership of the husband's portion will pass directly to the wife when the husband dies, regardless of what the husband's will says. For these reasons, you should carefully review the beneficiary designations on all your life insurance policies, retirement accounts, and anything else that might have a beneficiary designation. You should also carefully review the words used to describe how you own real estate. This can be found on your deed, and how bank and investment accounts are titled. That is the account named husband and wife joint savings account, or is it named husband savings account? Ultimately, in order to avoid probate, you'll take advantage of beneficiary designations and ownership type. You can discuss in more detail exactly what to do with your attorney. For now, you should examine your current beneficiary designations and ownership type of assets. This will give you a good head start on completing the estate plan after all the documents have been signed. Now let's talk about the revocable trust. The revocable trust is the most misunderstood part of a probate avoidance estate plan. The concept of a trust is foreign to most individuals, and the revocable trust is particularly confusing because of the purpose it serves. A trust is an arrangement whereby someone, known as the trustee, agrees to hold assets for the benefit of someone else, the beneficiary. A revocable trust, sometimes called an inter vivos or living trust, is created by someone, known as a settlor, during the settler's lifetime, and the trust may be modified or revoked by the settler. There are other types of trusts which aren't relevant here, but to give you some perspective, here are three main types of trusts: revocable, irrevocable, and testamentary. An irrevocable trust can be created during a settler's lifetime, but it's not subject to modification or revocation. A testamentary trust is created by the terms of a will and is irrevocable once it's funded. A revocable trust is used as the fundamental disposition document in a probate avoidance estate plan, and for this reason, sometimes such a revocable trust is called a will substitute agreement. That's because the will in a probate avoidance plan merely pours assets into the revocable trust, and the revocable trust then directs when and where the assets are distributed to your beneficiaries. Let's look at an example so you can understand how the trust works. Assume a fellow named John Yossarian is a single guy, and he wants an estate plan. He wants a plan that's simple to administer, complete, and private. So John's estate planning attorney suggests a pour-over will to a revocable trust. This combination of these two documents will achieve John's goals. It's simple because all of John's gifts will be controlled by one document, the revocable trust. And it's complete because everything John owns at his death will be transferred to and administered under the trust. It's private because the beneficiaries of the trust and what gifts they receive won't become public records, like they would be if the gifts were set forth in the will, and this is because the will is always filed with the probate court. These documents by themselves won't necessarily avoid probate. To avoid probate, John will need to take some additional actions. When he goes home with the signed documents, he'll need to place his assets in the name of the trust. To do this, he can retitle the assets in the name of the trust, or he can place payable on death beneficiary designations for the assets. These would name his trust as the payable on death beneficiary. For example, John can transfer all of the funds in his bank account to a new account that he opens up in the name of the trust. Or he could simply name his trust as the payable on death beneficiary of his current bank account by filling out a form at the bank. Then John names his trust as a contingent beneficiary on all his life insurance policies. This way, Upon John's death, assets will avoid being paid to his probate estate, and instead, the assets will be paid directly to his trust. This is how the plan avoids probate. Since John is the one who created the trust, he's called the settler of the trust. Sometimes this position is called donor or grantor, but we'll use the term settler here because it's the most precise. While John's alive, he'll be the trust's only beneficiary and only trustee, which means that he receives all the benefits from the trust, and he's in charge of managing all the trust's assets. Since John has the power to revoke the trust, he has full control over all of the trust assets. If he wants to use or sell an asset that's titled in the name of the trust, for example, if he wants to withdraw funds from the trust's bank account, he simply shows the party he's dealing with a copy of the trust, or a shortened version of the trust called a certification of trust, which is proof that John has the legal authority to deal with the trust's assets. John will probably need to show the certification only once, the first time he opens the account. When John dies, all of the property that's not already titled in the name of the trust will be transferred to the trust, either by payable on death beneficiary designation or by his pour-over will, or some of the other techniques that you can discuss with your attorney. Someone appointed by John in the trust agreement will take over as trustee, known as the successor trustee. Since John's dead, and he was the only one with the power to modify the trust is now irrevocable. The successor trustee will now manage the trust's assets as directed in the trust agreement, and this might include distributing the trust's assets to beneficiaries in a lump sum, or continuing to manage the trust while making periodic distributions to the beneficiaries. So how do you figure out what the successor trustee should do? Should he make a lump sum payment to the beneficiaries, or continue to hold the assets in trust? Well, you can work through the details of that with your attorney. For now, consider the following questions. Who do you want to get the benefit of your estate and your assets? If you want multiple people to get the benefit, how should the assets be divided among them? Equally or unequally? By a percentage or by a fixed amount? When should your beneficiaries receive control of the assets? And who do you want to control the assets until your beneficiaries have control? As an example, I find that most people with children have the following preference. You don't have to do this. This is just the most common thing I see. The surviving spouse should receive ownership and control of all assets when the first spouse dies. After the surviving spouse dies, all of their children should receive an equal benefit of the assets. If the children are adults, the assets should be divided equally among them and given to them outright immediately, which means they have ownership and control of the assets. But if the children are minors, the assets should remain held in a single trust for all the children's benefit and managed by a responsible and trustworthy friend or family member until the youngest child finishes their education. Then all the remaining assets should be divided up into equal shares and given outright to the children. You can discuss your particular preferences with your attorney, and they can answer any questions you have. Thank you for taking your time to watch this video. Your efforts will greatly improve the quality of your conversation with your attorney. I hope you found this video informative, and I wish you good luck.